Man, spring is springing.
Spring is springing and you are live.
Great. Welcome. Ooh, I don't see the red dot, but that's okay, I guess. Good morning, everybody. Welcome to Senate Economic Development, Housing and General Affairs. We're meeting remotely. It is Monday, May 18th, and we are here to hopefully land our landlord tenant bill H772. And we have a new draft to consider that has, I believe, addressed what we can address. And there are a couple things that we were still discussing, which Cameron, our legislative counsel, will address as we hit them during the course of reviewing the draft we have in front of us. We asked that anybody who had concerns about the draft be in touch before this meeting, and I have heard from nobody. So Cameron, if I think if we could just check off sections and go through it, I think that would be great, because I have the feeling we may be ready to pass it out with the exception of that 90-day discussion, which I just think we have to have because it hits a couple legal issues.
I would be happy to. For the record, Cameron Wood, Office of Legislative Counsel. I just sent around draft 2.2. This is a draft of the most recent amendment that I received back from our editing team. So it has been edited. And so that is the version that I'm going to reference.
Okay. Can you just, sorry, Cameron, I hate to interrupt, but can you just tell us how it differs from the draft 2.1, which you circulated?
It's just been edited, so there are a few, minor changes throughout the document to, ensure that the wording matches our drafting style.
Okay.
So, but the kind of primary, I would say the biggest change is in the third instance of amendments, which I'll mention in a second when we get there, because you can probably see that the page number has increased from the draft 2.1 that I've sent you previously. But I'll mention it when I get there. So, okay. I'm gonna share.
I will. Okay, great. Go for it.
Okay. Second, while I'm sharing. Okay. So, in the first instance of amendment, this is where we have kind of left off the past times that we were meeting and discussing. It is striking out section 1 of the underlying bill and the report of the Judiciary Committee, and you've removed most of the references or most of the sections that were in the bill as it came over from the House, from the residential rental agreement chapter. So as I mentioned previously, this is removing the cap on rent increases, the cap on security deposits, etc. So what we have here is what remains, making amendments to the termination and the requirements for termination of a tenancy. Based on the conversation that we were discussing just last week, I've added back in this subdivision 3 regarding information that's required to be provided. And I just want to pause here for a second, and I want to get back to the discussion that we were having last week. You all asked if there was information that was required to be provided in a notice to terminate. And what I said, and I want to be clear, that there's nothing in the statute. The only thing that the language in this residential rental agreement chapter requires is that the notice has to include the actual date of termination. And it has to be provided by giving actual notice, and actual notice requires that the individual defendant tenant has to have received it.
Right.
Other than that, the statute is silent. Now, the courts have added some additional kind of requirements here. So if you're terminating a rental agreement for non-payment of rent, you have to inform the tenant that they have the right to cure if they pay the amount of rent that is outstanding due through the current rental period. So because the statute allows the tenant to cure through the current rental period, you as the landlord need to provide the tenant with information on how much money would have to be paid in order to cure. That would be kind of required via implication of the language in the statute. So that is information that has to be provided. Separate from that, the court has articulated in a decision that there are principles that the tenant cannot speculate, and I'm quoting from the case, the tenant cannot be put in a position of having to speculate on the meaning and legal effect of landlord's actions, end quote. So by reading into that, you can also, I think, argue that a landlord is required to provide the tenant some level of basic information on what the termination is for. So if you're going to terminate because of the breach of the rental agreement, you're going to need to specify under what provision and provide them with the date of termination, how much time frame they have left, and you're probably going to need to give them some basic level of understanding of what they did, what the tenant did that is giving cause for the termination. Now, you then ask me, well, exactly what needs to be required? I would say back to what I mentioned at the very beginning. The statute doesn't specify. So it's really going to be a fact-specific scenario. And, I don't have anything from the Supreme Court that I can point to you to say, this is exactly what's required. So that's kind of the current framework that we're dealing with. Again, nothing required in statute. However, the courts have articulated that tenants need to have some, base level of understanding so they're not left to speculate on, what they're being terminated for and what is the legal effect of the termination. So what this sub 3 would do that you have on lines 8 through 11 is for a termination for the breach of a rental agreement under subsection B, which if you recall, there's a B1, which is for breach of the material terms of the rental agreement or for obligations imposed under the chapter. And then there's the B2, which is a termination based on criminal activity, illegal drug activity, or acts of violence for bill as it came over from the House. So I inserted it here. And I'm happy to pause there because I don't know that we've spent much time discussing this language. So I'll pause for here and take any questions.
Affidavit. Oh, I need that.
Yeah. Sorry, I was trying to grab the statutory section just in case you guys wanted to reference back to it, but hang on and I'll show. Yep, there you go.
Keisha, are you virtual or are you in the room?
We're all virtual?
Yeah.
I'm not in the committee room.
Yeah. Cameron's in the committee room. I'm just,
Yeah.
I just couldn't tell. David, you have a question.
I'm just curious about the relevance of the word affidavit. What's that really mean? If I was a landlord, do I have to go to the court to get an affidavit, or is it a self-attested document?
I can give me 1 second. It's it's essentially a legal document that you are swearing to the truth and the accuracy of it. I don't think it's
Sorry, I lost the language again. Could somebody, I don't know how to help you, Cameron, make sure you can look at your notes.
Yeah, that's okay.
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 Lost the screen share.
So it is a, written document that you as the individual producing it are swearing to its accuracy. This is, typically going to be used in the court context. because, you can perjure yourself if you're providing, inaccurate statements in a legal proceeding, and there are, legal effects and legal consequences that come with that. I think the key here is that you're providing this affidavit. It wouldn't, I would argue, it wouldn't be required to take any exact form.
Okay,
There
that's
is-
kind of my question.
What I would say though, to keep going further, there's some changes down here below. My apologies for the scroll. So in this section here, which is on page 5, this would require that a copy, here on line 6, a copy of the affidavit would have to be attached to the complaint that would be filed in an ejectment action. So you, as the individual, landlord who's providing that information, there ultimately would be consequences if you're falsifying the information in the document, because you have to include a copy of it with the complaint to the court if you got to an ejectment process.
Can I just triple check we're talking about an individual who has a lease agreement or this is where think I still have a fight with finance, but this is only if you have a written rental agreement, not if you are a long-term tenant by virtue of staying longer than a month.
The Vermont statutes do not require that a rental agreement be in writing. So it could be a written agreement or it could be a verbal agreement. And this would apply in the situation where you as the landlord are wanting to terminate the agreement for breaching the terms of the agreement. It would not apply. You would not have to include an affidavit for terminating a rental agreement due to non-payment of rent.
Okay.
Or if you're terminating the rental agreement for no cause, simply because you want that individual to no longer be living there, and you're terminating it at the conclusion of the written term. Or if there is no written term, then you have to provide 60 or 90 days notice, but you do not need cause. So you would not be required to include this type of affidavit under those scenarios.
So this affidavit is only, we are now looking at requiring this if you are going to terminate the lease before the end of the lease agreement, before the end of the lease period, whether it's verbal or written, that understanding of what.
Right. So, as I've kind of mentioned, think about it this way. If you have a written agreement or your month to month, and the landlord wants to terminate at the conclusion of the written term, or if you're month to month and the landlord simply wants to, terminate the agreement with you such that you have to leave, then the landlord has to provide a certain notice period, but they don't have to give any cause, any reason. They just have to make sure that they're giving you either 30, 60, or 90 days as the statutory scenarios require. That would be, 30 or 60 days before the expiration of the written term, or 60 or 90 days if you're in a month to month with no written agreement. If you have a written agreement, whether it's, let me back up. If you have a rental agreement, whether it's in writing or not, you can also terminate because of non-payment of rent. And then if you want to terminate because the person is breaching the rental agreement, then a scenario that would be under B. If it's
B1 and 2.
Correct. And that could be if there is a written agreement in the middle of the term of the written agreement, or it could be if there is no written agreement and you're simply wanting to provide a shorter notice period, because the B2, for example, comes with a much shorter notice period than doing a no-cause eviction. In some instances, landlords will move forward with both. They may terminate the rental agreement for cause because of breach of the rental agreement. And then if you you don't have a written agreement, so you're month to month, they may also terminate the agreement for no cause, and they may use both of those bases to move forward.
So this is adding, this is really giving tenants and helping tenants understand why the landlord is moving to evict them in the middle of a lease agreement. Right? I mean, that's what this does. This ensures that the
Yes, and once it's in writing, it gives them more ability to go seek out information about their rights than
exactly.
they would be able to otherwise.
Yes, I agreed. Thomas, you have a question.
Cameron, I know you've gone over this and I just confirm, when they have a lease agreement and they come up with this reason, will this then justify differing amounts of time while they're in a lease agreement? Could this possibly, based on that reason, the affidavit mean 90 days versus 30 days versus 15 days?
Give me 1 second, because I want to pull up the statute in this regard for this conversation, for this piece.
Cam, we again lost the screen there, which you may choose something else to show us in a second, but I just want to let you know what we're losing.
So I wanted to pull up the statute specific. So if the landlord is terminating the agreement under B1 or B2, that comes with a 30-day notice period or a 14-day notice period. And so, the landlord can provide a longer period if the landlord so chooses. It just has to be at least 14 days or at least 30 days if you're terminating the agreement for breaching the rent agreement. This is what the affidavit would apply to, are these two scenarios. Any other scenario, the landlord would not be required to provide this level of information.
Okay. Can I ask a question there?
Okay, yeah.
If we're talking about termination for these two reasons, you are filing an affidavit in court. Hence, it's an affidavit because you're submitting it to the court. For everything else, you're just hand delivering or certified mail to the tenant.
Correct. I would say one thing slightly different. At this stage during the kind of the process, you're providing the termination notice to the tenant directly. So the landlord would not be required to submit this affidavit to court at this stage. The landlord would submit the termination notice to the tenant with the affidavit included. And then if the tenant remained on the premises after the date of termination in the notice, then the landlord would have to file in court an ejectment action to get a writ of possession to remove the person from the property. And when they file that complaint in court, the landlord would be required to include the affidavit as part of the complaint.
Okay, so then I do have more questions about what we mean by affidavit before it's required to be filed in court, because I do believe an affidavit has to be notarized.
Does it? I mean,
I'm not aware, again, kind of a plain language reading of affidavit is just a sworn written statement.
But if it's sworn, that's the problem. You can't, I don't think you can have a sworn document if there's no witness. So I don't think we should use the word affidavit before it goes to court.
Yeah, I was going to say, you can take the word affidavit out if there's kind of consternation about it, then you could just say accompanied by a written statement.
okay, David has a question.
Thank you. So I'm still back at the word affidavit, and I appreciate when we meandered around to come back to that conversation. So I just want to summarize. So an affidavit is written, yes. An affidavit is sworn. I think it's yes. An affidavit is notarized. I believe that's yes. And the affidavit is via the court system. And I believe that's a yes. Are all four of those accurate?
So I'm not aware of any requirement in Vermont law that requires that any affidavit to be given legal effect must be notarized. I'm not saying it doesn't exist. I'm saying I'm not aware of that legal requirement. I can inquire with our office to see if that is a requirement. And if that is the case, somewhere get
Got it. Okay, so
I would just
notarized.
say, oh, go ahead.
Yeah, let me, if I can just wrap up this one.
Yeah.
So notarized,
And
notarized maybe, written yes, sworn yes, via the courts yes. That's the substance of an affidavit as we understand it this morning.
right. And the
Okay.
question is, does it need to be notarized? I think
Okay.
that's hanging.
Right.
question.
Okay, so I understand all that. So at someone's point a moment ago, removing the word affidavit, I would support removing the word affidavit. I don't think we need to instigate a legal process that onerous. And if there's a more appropriate word that makes sure that everybody's notified, but doesn't require court acknowledgement, I would support that.
Okay. I think Keisha
Yeah.
would.
Well, and to just save us time asking judiciary, I mean, having worked in some of the family court, like a step below criminal court, they tend to require you either sign it in front of them or have a notary. So I don't think we should get into all of the, is this a con law thing or not, but just, it's not, I don't want to say affidavit or sworn statement because I think that's the next level of court process.
I
agree.
okay.
There is a section in statute, and thank you. An individual point this out to me as well. There's a section that allows for self-attestation in lieu of requiring or in lieu of having to be notarized. So I'm not trying to sway you one way or the other about using the word. If there's uncomfort, in using it, we can take it out. But there is in statute the ability to include specific language that would negate the need to have the document notarized. And I could pull that up if that would be helpful.
Well,
No, I'd rather just we change the language.
but the plus of having an affidavit is that somebody has to not it has to have a sort of a second.
But we are talking about mom and pop too. And I just think like we don't have to put an ambiguous requirement on people that could be used against them should they not have sworn it properly, etc. I think what I'm saying is I don't think we need to require a
Right.
sworn statement of any kind, even if it's self-attested at this point. It's
Okay.
a communication, just like other landlord-tenant communications.
I would agree. I would at this moment, let's let affidavit go.
Is written statement okay?
Yes, I think it needs to be a written statement. Yes,
That's good.
I think that's good. I mean, what we're wanting to do here is to provide a reason for why the termination. Thomas, that's very funny. What we're trying to do is provide a reason to the tenant as to why the lease is being terminated in the middle of the lease.
Okay. I can make that change. So then moving forward, we're back to where we were just last week. We have this language here in subdivision 4 and 5 for being the prohibition on terminating a rental agreement due to an individual being the subject of a good faith medical request for medical assistance for a drug overdose. And then when we get to 5, there is the language around the bifurcation. And then we were here in the bifurcation section as well. So before I move forward, I'll pause there because that's where we were last week.
Because hopefully we're checking off these sections. So before we leave, is everyone okay with 3 if we remove affidavit? Okay.
I'm okay with it. The only concern that I have overall is it's it's funky and overly legalistic. And I think of that tenant who is the low rent tenant. It essentially pushes anybody towards a lawyer at this point, whether they need one or not.
Well, that is often the case with a termination. So I would
And I think it also pushes them toward legal help. So
exactly.
someone who can give legal advice, which there are clinics for.
And also, quite honestly, it gives them a reason for what's happening, which often they don't have. So if everyone's okay with 3, I'd check off 3, and we're now on 4 with Randy's addition of solely. Are we all okay with that?
Yes.
Okay.
Yeah, we're talking about line 12 through 18. Yeah,
Yep.
I'm still a no. I'm still a no.
Oh, you are?
I
Okay.
certainly am. I have been all the way
Yep.
through. Yep.
Oh, I appreciate.
Too much to ask. Too much
Yep.
to ask for mom and pop. You're a state subsidized housing agency. That's different. Mom and pop, it's no way. Can't go there. I'm very sorry.
Yeah, no, I can appreciate that. I just also think, well, anyway, I think a mom and pop would rather not have somebody dying in their apartment either. So 5, Cameron, I just needed to get a sense of where we were as we move through these changes. 5 is the bifurcation.
Before we go to 5, I would like to go back and ask Senator Weeks if there is any modification to that section that would address his concerns. And I know that one of the concerns we certainly talked about, is one of my concerns too, is if you essentially are operating a drug den as opposed to, in effect, a single incident where a person has a problem and deals with it. No landlord, particularly the mom and pop landlords, want to be in a situation in which they have extensive drug use in a property that may be next door to them or downstairs from them, et cetera. And that is, I think, a valid concern.
Randy, it's a valid
Whether or not Senator Weeks has any thoughts about how that could be dealt with and still have the landlord's ability not to be stuck with that for a recurring situation.
Before David gives his answer, I just want to remind us all that that is an illegal activity that's taken care of, and you can eject somebody under B2. So I believe, unless Cameron, unless I misunderstand that, illegal activity is already taken care of in B2. You can evict someone for conducting illegal activity, and drug dealing and is an illegal activity.
So how about drug use?
Yeah, it's all about drug use. We're not talking, we're not trying to go down a different path of drug marketing or what have you. It's all about it's drug abuse, drug overdose, mom and pop environment.
So
to answer
Randy's question, what could get you to yes on that section?
I get it. I have not yet heard any language that satisfies this, trying to balance out the person in recovery versus the person who's overdosing. I just simply think that the risk to the landlord with an environment of overdosing is beyond what we should be asking our state landlords to absorb. But short answer, I haven't heard language that gets me to yes on this section.
Well, the question for those who are fervently in favor of it, do you have any language that you would suggest that addresses Senator Weeks and my, for that matter, concerns?
Well, I mean, I just want to step in and say, sorry if I missed this, that judiciary passed this language out 5-0.
Right.
And this was, when there was consternation about more criminal matters that wouldn't be addressed because we're trying to prevent overdoses, fatal overdoses, then judiciary wanted to weigh back in and say, this section's important to us. So we could get Senator Hashim to speak to us, but that's the thing is, they looked at this from the criminal and life value perspective, which
Understand
is not
notion
landlord-tenant law.
of preserving life, and that I'm sympathetic to, which is why I inserted the word solely.
Right.
So that is not the sole basis for the decision. But operating a disorderly house in which people are going in and out and obviously showing signs of impairment, that is the kind of thing that I'm thinking about. Whereas continual behavior, as opposed to
Oh, yeah. Well, so I don't know if we're arguing. I agree, Senator Brock. I think I think the word solely is a good one, and that I think everyone's intent is to make it specific to a life or death situation and the evidence surrounding that, very brief period of a life or death situation, and all other patterns of behavior that point to criminal activity are very much a part of this ejectment. That
Right.
essentially voting no, I don't want to say this for Senator Weeks or anybody else, but voting no would mean they don't have this tool for patterns of drug use and other criminal behavior. Just
Right.
saying.
So I would suggest that unless I appreciate that David is a no on this section at the moment. I would hope we have, that Randy is considering supporting it given the addition of solely. And we can think about it, but let's put a pin on this as one of the last things we have to resolve and move forward with appreciating the other changes so that we can agree, hopefully, on the rest of the changes that we have in front of us. So let's come back to this. Let's keep moving. And because we have the bifurcation here.
Okay, so we're.
And wait a minute, and just last, I had to ask both Randy and David to chat with Bob Norris, and Chris Matos, who voted to support this, and I just was hope that they did that, and I just don't know the outcome of those conversations. Just to go back to what Keisha said, the judiciary did vote this out 5-0. So let's keep moving to the bifurcation piece, 5A and B.
Okay. So we've talked about this section a few times. The 5A says that a landlord shall not terminate the rental agreement of a protected tenant because of an incident or pattern of domestic abuse, sexual assault, or stalking. So that's intended to protect the victim in the situation where there is some sort of, domestic abuse, sexual assault, or stalking, something that could rise to the level of criminal activity in the unit or acts of violence in the unit, to ensure that the landlord would not evict the tenant in that situation, the victim tenant. And then the sub B is that the protected tenant may request to bifurcate the rental agreement as authorized in section 4472A. 4472A is going to be here in the second instance of amendment. You're proposing to strike out this section from the judiciary report and insert in lieu thereof this new section. And the only change in the information is the change in this subdivision 3 on lines 12 through 14, page 4. And so this is where you've talked a bit about this subsection B, which requires that when there is a bifurcation, the landlord has to provide a reasonable opportunity to locate additional tenants or otherwise find new housing, and that is to be not less than 90 days. And there's been discussion about, well, what happens in the event that the tenant is not able to pay for the entirety of the rent during this period? And the subdivision 3 was being added in to make it explicitly clear that nothing prohibits the landlord from collecting past due rent or recovering losses due to damage. How I read this section is the landlord is going to be required to give that protected tenant 90 days. And then at the conclusion of 90 days, if there is unpaid rents, then the landlord would be able to move forward with terminating the rental agreement due to non-payment of rent. But the landlord would be precluded from doing that during this 90-day period. And this is where we left off with questions around this section the last time we were here. So I'll pause.
Thank you, Cameron. Cameron also did some additional work on this and found out that the 90 days is federal law, I believe. Is that correct?
So my understanding is that the general federal law timeframe is centered around 90 days, but I'm also trying to get that exact statutory citation. So if I can find it while we're sitting here during this hearing, I'll provide it to you. But this is, if you all recall, this is based on, you know, similar concepts around bifurcation of rental agreements that is in the Federal Violence Against Women's Act, you know, protections. And so my understanding from the advocates is that 90-day period would coincide with the general protection that's under federal law for a similar type of reasonable opportunity.
Got it. Thank you. That's helpful. So after the 90 days, the landlord, if the rent has not been paid and an agreement has not been reached about how they would manage staying in the apartment and affording it, the landlord is able to move to collect the rent, to eject, or to eject if they have not paid the rent.
Correct. That's how I read the section. And
Okay.
I have not heard any objection from others who read it differently.
Right. Thank you. That is, so that clarifies it a bit for me. Any thoughts from the committee? How are people feeling about this? This then definitely allows, so instead of just, yeah, anyway. Any thoughts? Keisha, do you have a thought? Randy?
Well, I mean, I don't even know. I'm about to get on my computer instead of my phone, but here I am, just reading the language, and I'm just reading between reasonable opportunity to locate additional tenants versus finding new housing. The thing is, there, I don't think that's a federal thing. And I'm focused on the locating additional tenants. Sometimes the landlord wants to take more responsibility for that. They don't just sort of want the person saying, I'm trying to find somebody else to share my apartment. Just a lot, without saying more, like a lot can go wrong if you're like, you know, just leaving it in their hands to find new people to live with.
Oh, I don't think it leaves it in their hands. It allows for opportunities both for the tenant, the affected tenant, the protected tenant, to either find new housing or to find an additional somebody that could come
Do
in.
we, I
call.
guess, like, this might be a question for Cameron, but why do we have to be so specific about locating additional tenants?
I don't know that you need to, but I think the concern, as I could see it, is you have a scenario where the landlord is renting out rooms within a house. And so you tenant only have one room that you rent, and, you know, or, you know,
What
you-
would happen then? I'm sort of trying to follow your.
Yeah, I don't understand that.
Okay, so when you look at the federal law, it says that the public housing agency shall provide remaining tenants, and this is after you've bifurcated the lease, or resident an opportunity to establish eligibility for the covered housing program. If a tenant or resident described in the preceding sentence cannot establish eligibility, the public housing agency shall provide the tenant or resident a reasonable time to find new housing or to establish eligibility for housing under another covered housing program. So I think the thought here is you have multiple tenants in a lease. You have bifurcated it and removed one of those tenants. And so now the individual tenant who remains may not be able to meet whatever minimum criteria the landlord has set out in.
Meaning they're not
Hmm.
individually eligible for that program because they didn't meet another eligible category. We're talking about public housing. I mean, I guess because this is applying to all types of housing, I don't think we need to be that specific about the tenant remaining on the lease agreement.
So how about if,
They don't have to find other people to live with if they can figure out another way to pay the
so I
rent.
think what we're trying to get at here is a reasonable opportunity to solve the problem that they have, which is how to pay the rent. And so I think they giving them a reasonable opportunity to both find new housing and figure out, if you could say in legal language, figure out how to pay the rent is, I think, the issue, isn't it? I mean, it's up to them whether that means an additional person or
Right.
selling something or doing something. It's up to them to figure that out, but it may not be. I mean, I think what we want is a reasonable opportunity for them to solve the problem.
Well, before we go on to that, if you go up into B1 above, this is a question I know that was raised before, and that was provided a reasonable opportunity to locate additional tenants or otherwise find new housing, followed by a reasonable opportunity under this section should be not less than 90 days. And I know I raised that question in our last meeting, that essentially what you're doing is you are forcing the landlord to provide 3 months of free rent.
Right. And so I
And
think
that shouldn't be.
no, we talked about that, Randy. You're absolutely right. But I think before we get to the 90 days discussion, I think what Keisha is asking for is in the lines above that. How can we simplify that on lines 8 and 9 before we get to the 90 days? Because that's another question. How can we simplify that and really just give them a reasonable opportunity to find a path to either paying the rent or finding new housing? I think that's what we're asking. So did you have a suggestion, Cameron?
I can understand the concern with this language. We could redraft it to say something like a reasonable opportunity to meet the minimum requirements of, the rental agreement.
How about just saying, just to meet the requirements of the rental agreement?
Yes,
How about that?
yes.
You're asking me to think on the fly, so yes, I'm not seeing an immediate red flag in my mind, but I will continue to think about it as you continue to discuss amongst yourselves.
Okay, great.
And the thing I think that obviously we will be thinking about as we head down to paragraph 3 is, what is a reasonable opportunity? What does that mean in real life?
Well, I think it's a reasonable opportunity that any reasonable person would understand was giving somebody time and space to try and solve the problem they have in front of them.
Yeah, but what does that mean? And it means different things to different people.
Well,
Yes, and I mean so I thought for some reason that Cameron had taken out the 90 days. I know it's important for VAWA purposes, but and that might be related to public housing, which has a lot of paperwork. At the same time, it then begs the question, when does the 90 days begin? When the new written lease is drafted that just has their name on it. I did domestic violence work for years, so I'm not trying to say this to be contrary, but I think the 90 days is very hard to enforce when you're talking about small landlord tenant agreements versus public housing. And we just have to remember this bill is attempted to be written for large and small landlords, where this is a lot of paperwork or something that many don't do.
And an additional, as Randy had said earlier from our earlier conversation, an additional cost burden to trying to do the right thing and give somebody who's going through a lot of trauma time to figure it out, but also not wanting to put an undue financial burden on a smaller landlord for whom 3 months of rent is a lot of lost income. So this, I think what I heard Cameron say is this could be shorter. This 90 days is federal law, that it could be shorter for state law. And although I think that the federally subsidized housing units would still have to comply with the 90 days for other, so I guess I'd love an answer to that question, Cameron. But if we wanted to set this at a shorter time frame, let's say 30 days or 60 days, that we could also do.
Correct. These provisions are based off federal protections that would apply to housing programs, utilizing federal dollars essentially. And there's a definition of covered housing program, within these regulations that would articulate exactly what housing programs the federal law would apply to. But just, for the most general statement, it's going to apply to federally subsidized housing programs. You're putting this into state statute, which would apply to any housing program, or excuse me, any housing across the state, both, state housing dollars and private, landlord tenant relationships. So you're not obligated to follow or match the time frame outlined in federal law. You could make it 30 days, you could make it 60 days. As you're aware, this protection doesn't even currently exist. So you're
Okay.
not obligated to match what's under the federal law. Just understand that, your federal housing programs or housing programs in the state utilizing federal dollars are required to comply with those federal program requirements.
Right. Thank you. Appreciate it. David, you have your hand up.
Oh, sorry. I don't even know how to put my hand up on my phone.
No,
I do.
okay.
Thank you, Madam Chair. So at 10,000 feet, I agree with bifurcation. The concept is good. I get it. What I haven't heard is, I've heard of, a lot of effort to relieve the tenant in this scenario, unfortunate scenario. I get that. But what I'm not hearing is relief of the non-public housing sector, such as relief from taxes, relief from mortgage, relief from utilities. And it took about 10 minutes in this conversation to kind of boil down the fact that the language which we were talking about is federal language about subsidized housing. And I get it for subsidized housing. Government's got a stake in it, federal government, state government, but not the mom and pop. And we've got to protect the mom and pop. So if we're talking about reduced, reflecting on the 90 days to some, shorter time frame, I could support that, but I'd like to hear from the others in the committee.
Right. Thank you, Keisha.
And I have housework happening outside, so if it sounds loud in the background. I have kind of an out of the box thought, which is that and I don't want to distress Cameron, but that we would double the length of time of the other types of ejectment decisions for if there's domestic violence and the person wants to have a reasonable opportunity to bifurcate. Does that make any sense?
That question's to Cameron. I'm not sure I understand it
So the way this is set up is you cannot terminate the rental agreement for the victim, the protected tenant, due to those instances. So it allows you to bifurcate so that you can terminate the lease agreement for the perpetrator who is engaging in the activity, but you cannot terminate the rental agreement for the victim under these provisions. You would need some other reason to terminate that individual.
Such as non-payment of rent.
Could be. Yes, sir. If you're
Because don't all those obligations
my apologies. Yeah,
to the protected tenant?
my apologies for the scroll back up. What we're talking about here is we're talking about this subdivision 5. And subdivision 5 is going to exist under subsection B. So
Right.
this is the landlord wants to terminate a rental agreement due to breaching the rental agreement terms or doing some other criminal activity or acts of violence that threaten other people. And this 5 is saying that you cannot terminate the rental agreement for those actions of the protected tenant. But you may bifurcate the agreement down here under this new section. You may bifurcate the agreement to eject or remove the individual who is engaging in the abuse, sexual assault, or stalking.
Right.
So in that instance, it's a protection to say you cannot eject the victim. And the question then becomes here, as you've been discussing in B, this is saying that if that protected tenant is unable to cover the rent of the dwelling unit because you've now bifurcated and ejected the abuser, and so you only have the victim who remains, if that individual is unable to cover the rent cost of the unit, do you want to include these protections that kind of align with what is under the federal programs?
Right.
And so there wouldn't be, I guess, getting back to Senator Ron Hincy on your question, there wouldn't be any, I guess what you could do is you could extend the termination notice period for terminating a rental agreement due to non-payment of rent. If it is the protected tenant, you could extend the termination notice period under that section to give the protected tenant a little more time. I think that would answer your question of how you would go about doing that.
But that's what this section is already doing. I mean, it's already giving the protected tenant more time to solve the problem in front of them, which is how to pay the rent. If they aren't the majority, if it's a challenge. Thomas, I believe you had a question.
I didn't want to take us off this thread.
Oh, okay. So is it on this subject?
The previous point, but.
Oh, okay. Go for it.
All right.
I mean,
So Cam, earlier in this discussion, it was raised, and I don't remember a clear answer. I think there is one, but to Senator Weeks' previous points, is there any way or precedent to treat or distinguish types of landlords, be it nonprofits versus the mom and pops? Is there a definition that lines could be drawn along those? I just don't remember a clear answer to that inquiry.
between sort of private landlords and public and
Nonprofits like CHT. So if there's any categories of landlord where some of these rules could apply and not elsewhere?
In the state statute, the residential rental agreement chapter, I don't recall there being any definitions that distinguish between them. But, in practice, right, you do have a lot of these programs that are set up either at the federal or state level where you apply them to housing entities, public housing authorities, landlords that receive those state or federal dollars. And then, typically those entities are set up as nonprofits in order to receive those funds. So in practice, it happens that way, where you have the distinction of where these programs apply to, nonprofit entities receiving state or federal dollars. The statutes, the residential rental agreement chapter isn't really set up that way, but you could set it up that way. You could apply these provisions that we're discussing here regarding bifurcation to, state entities that receive state housing assistance. And if you were to do that, I would strongly advise you to match the federal law exactly, because I imagine most, state housing authorities that are receiving state housing dollars are probably also receiving federal housing dollars, and I don't think you would want them to apply different programs depending on which funding stream. I assume you would want that to be universal. I hope that's a very long-winded way of trying to give you information regarding your question.
Yeah, well, yeah. So is it a long-winded way of saying what's good for the goose is good for the gander, that we have to make it sort of more universal? I mean, that it should apply to everyone?
So
No.
you don't have to apply it to everyone, and you don't have to apply this to anyone. And again, it's not current statute. And so if you wanted to distinguish that it applies to certain landlords of a certain size or certain landlords receiving state assistance, you can do that.
So we could bifurcate it by type of landlord. Okay, I'm sorry, I misunderstood you. So we could so we could leave what's in place here for the nonprofit tenant landlord for whom this already applies. I would make the change, though, before we get into the 90 days, I would make the change on line 8 of the reasonable opportunity to meet the requirements of the rental agreement, period. And then we could, for nonprofit landlords, include 2 and 3, and then for private landlords, we could reduce the time frame perhaps, and consider 30 or 60 days for people to maybe 30 days for people to work out their arrangements, and then after which, in both cases, the landlord can move to collect the rent that's owed them.
May I ask a question?
Yes, of course.
Do we not, for example, some of the Section 8 housing, aren't those private landlords?
They could be.
Yes, they are.
And
You're absolutely right.
And so you get into that same situation. My concern basically is this, that when you extend the ability of a tenant, because of the circumstances we're talking about, to delay rent up to 90 days, you have a situation in which that private landlord still has the requirement to make payments on his or her mortgage. That affects their credit record. If they don't make it, it also affects their ability to retain their property.
Right. I appreciate that. I know Keisha has a thought, and I know we have Chris Donnelly and Jean Murray, and Chris has asked to weigh in, and I appreciate Chris weighing in on this point, and then we'll go to Keisha.
Hey, thanks. And I just want to say that these requirements, the Violence Against Women Act, the federal law, already apply to us. So putting it again in state statute would just be redundant. It may cause some complications. And I think the intent behind this is really, you have a tenant who has been traumatized by a relationship, and the intent of this language was to give them a little time so that they're not also traumatized by losing their housing at the same time. I hear the concern for landlords losing out on their rental income. I think grace period is fine if it's 60 days or 90 days is appropriate. But I think the language also doesn't let the tenant off the hook. I think they're still responsible for paying the back rent.
Right.
So I think it's trying to give that space to allow for someone that's in a traumatic situation to not have compounded by becoming homeless or losing their housing, but also ensuring that it gives some time for them to find the resources to pay the rent.
Right.
I think that's the intent, and I understand the challenges on both sides of this, but again, we're covered by this. That's fine. I hear you for the smaller landlords and that they may need a little support, but that would be my recommendation, is that if you want to shorten the time period, but protect people that are in a traumatic
Right.
situation.
Thank you. And in
Thank
both
you for letting me
in
weigh
both
in.
situations, Chris, they are able to pursue, no matter what the time frame is, they're able to pursue getting, reclaiming the rent if a reasonable, if something
Correct.
occurred. Okay, that's helpful. Keisha.
So the
Tom
reason
has a question.
that I'm sorry.
And then I think Thomas has a question after you.
Okay, so the reason that I'm arguing that we either use the kinds of situations that require certain lengths of time and not focus on other other types of landlords, et cetera, is because we've given a lot of thought to those timeframes and whether or not a challenging situation deserves more or less time. So in that would say we don't really even need to put a number of days in here. If somebody is experiencing domestic violence, but that's resulting in a non-payment of rent, that's kind of a different scenario than if they're experiencing domestic violence and the person is, removed per a relief from abuse order or some kind of protection order, and they really do need to figure out a lot in their lives. So we have reasons that we give people different amounts of time, and it should either be a metric like a double of those timeframes based on those reasons, or no time frame at all. We shouldn't have a random different time frame, and we don't need to say what type of landlord, because the types of landlords, as Chris said, that are covered know they're covered.
Right. So I think it's helpful for time frames. A more modest time frame would be helpful, because I think everybody needs to know kind of what they're up against, what time frame they need to operate in.
So
And
then use the timeframes that you can be in a domestic violence situation, but have a different impact on your housing depending on the reasons for ejectment that we just discussed. So we shouldn't have highly different reasons for ejectment and different timeframes. I feel like I'm losing you, Madam Chair. We just looked at timeframes
yeah,
related
no, I
to.
appreciate.
This is like we're not going to be able to figure out what's reasonable in Franklin County versus the Northeast Kingdom versus Chittenden County for all of these scenarios. We should use the type of situation that is causing an ejectment of the other party, which would then create the need to bifurcate the lease at that time.
So we're already creating this opportunity by bifurcating the lease. I think I don't see removing, I think.
Can you wait, stay with me here?
Yeah, because I don't
Because
understand not having a time frame so that
because the
people know.
reason for bifurcation is because you want to eject someone from the apartment that the other person did not feel safe or comfortable, or who knows what. That creates the reason for the bifurcation. We should look at the standards we've created for ejectment if we're then giving a victim of domestic violence, which it doesn't have to be documented, it doesn't have to be a court proceeding. We should use those existing metrics, because if you get a relief from abuse order, that person is out of your house overnight. If you can't pay rent because this person is not helping you and is in and out of your home and they're named on the lease, that's like a different scenario. So
Well, that's what this creates, is a different scenario. So I'm not.
No, it doesn't. It doesn't, because it's based on the reason this came forward is because you have varying events that might cause your landlord to eject a person in your household
Right.
based on some event occurring that gets them ejected.
Right.
Is
And
anybody else following what I'm saying? This is
I think
if someone's getting ejected and the other tenant steps in and says, I'm glad you're rejecting them, I'm a victim of their violence, then it really depends on if you're talking about the violence that they're experiencing or drug activity, et cetera, or if all of a sudden it's for non-payment of rent. Like, these are really different scenarios.
I see what you're saying is that if the bifurcation can occur, then we go back to the other ejectment opportunities which we've just created. If they are not able to pay rent, then those B1 kicks in. But that the bifurcation, that the other opportunities we've created would be sufficient. Is that what you're saying?
What I'm trying to say is that they at least need to relate, because this is not happening in a vacuum. There, in this section, there's no, if Cameron goes up, or I could be wrong, but you don't have to prove you're a victim of domestic violence in this case. So there's no time frame that starts any kind of clock. And the only time frame that starts a clock is the ejectment of another person in your home, who
Right.
you are then saying you might have been a victim of, and they were asked to leave.
Cameron?
I'm not sure if there's a question for me there. Or,
There's
Yes.
really not. There's really not. I struggle with this section because I do think a lot of the committees that looked at this before us were thinking of large housing providers and federal law, and we're not thinking about individuals in very individual situations where they rent out one place, or et cetera. I think this section is overwritten and problematic for most types of landlord-tenant relationships. And we should probably just take out the number of days if people are sick of hearing me try to explain landlord-tenant law.
The question is, if you take out the number of days and you're left with the question of the landlord shall provide the protected tenant with a reasonable opportunity, what does that mean will be the question that will then have to be decided.
Right. I agree. So that's, I don't, if you're going to bifurcate it,
because the courts decide reasonableness much better than the legislature.
I'm
That's
not worried.
why.
Right. I'm not worried about the reasonableness. I'm just concerned that if you have a tenant who's suffered trauma and needs a grace period to solve issues around that trauma, and the loss of one of the partners in the tenancy,
the trauma is different, because that's why there's ejectment conversations happening and why they go to court. So already, if they're in court for ejectment, if we write in law that a bifurcation needs to be made available to a victim of domestic violence, that can be brought up in the court proceeding around the ejectment.
Right.
And then the reasonable standard is performed by the court, which is much better at what reasonable looks like depending on the situation.
So you would suggest that we maybe fix the language in 8 and 9 about the requirement to meet the rental agreement, get rid of a time frame, and just keep number 3, make 3 number 2. And so that the landlord would not lose rent over the bifurcation challenge, that the bifurcation challenge would not require any additional accommodation. Is that what I hear you saying?
Are you asking me or?
Yeah, well, that's what I'm
Cameron?
hearing in this conversation. I'm hearing if we get rid of the time frame, that we ask, that the court would take
That's
care.
what I'm saying. Yeah.
Yeah, that the court would take care of reviewing whether the reasonable opportunity to meet the requirements of the rental agreement and get rid of any, that everything else will take care of the problem we're trying to solve. And that we keep the last sentence. Nothing in this section would prohibit a landlord from collecting the rent. But that could, I mean, I think the minus of losing any grace period for somebody is that you're then immediately, if somebody's going through the domestic violence challenge and somebody gets ejected, they don't have any, they aren't given, they have
They
to
do. They have a lot of rights because they have a written lease agreement, and they,
necessarily.
okay, if they don't have a written, that's kind of the first question I asked, because we are affecting a lot of tenants in all kinds of bills that we're doing this year who don't have a written lease agreement. I believe that many bills in many committees, Madam Chair, that we probably should have looked at affect people's ability to have an informal lease agreement. That is probably going away with the tax law that has passed out of the Finance Committee.
Okay, that we are going to lose Randy in a few minutes, and I would really love to land this section if we could, and land the other section, because I think we're okay on the court work. We did good work on that. This piece is, I think, I'm just, if we take out the days, I'm happy to take out the days, but I would like to change the language around finding additional tenants. And I'd like to keep the language that allows a landlord to recover the lost rent. So, but I also,
Well, essentially what you're doing when you do this, when you do any of this in this way that you're talking about, is you are making the one person to get punished in this, the landlord.
no, I don't think that's the case.
Because again, if the rent is not being paid because the tenant who is the protected tenant can't pay it or doesn't pay it, and you have ejected someone and that person doesn't pay it, who pays it? Well, the person who pays it, in effect, is the landlord.
No, the landlord then can move to eject them. The whole point of this is by removing this, the landlord, we go back to the ejectment opportunities earlier that we have discussed.
So the individual gets ejected, and then who pays the rent?
The landlord can move to collect that rent.
And then you have a reasonable period of time allowed, which is still under discussion as to how long that person has to pay the rent, if it's paid at all. And then you don't want to put the burden on the tenant. Now, you're doing that in the case of large nonprofits because you think it's whatever the rent is going to not amount to anything that's going to affect individuals. But what we're talking about here does affect individuals. It affects that small landlord who has to come up with a difference for however long we allow for
but that's the case. That's the case currently. That's the case currently. If there is, I mean, we are providing in law here an opportunity to make sure that no matter what happens, the landlord can move to collect the rent. That is, I mean, that's, I believe, Cameron, that's current law. They are ejectment, if there's an ejectment, they can move to continue to collect the rent.
Of course, if the person who's being ejected, that person's name is still on the list. Then the question becomes how the courts view that right now in terms of the responsibility. Let's say it's two people who are living together. One of them gets ejected, and let's say both of them are on the list. Then what happens? If they get ejected, one person gets ejected, and only one of them is on the list. What happens? It's almost as if we ought to have a chart that tells us what happens right now under the law in each of these cases. Who's responsible?
So Cameron is here to tell us. I mean, I think what we're trying to do is create a grace period for people who are going through domestic violence trauma. That's, I think, what this section is about.
No, and I don't disagree with you, and I don't think that's necessarily a bad thing. However, what I'm saying is,
I know I don't want
pays for the grace period.
I don't disagree. The question is, we can't force anyone to pay the rent if they don't have the money. What we're trying to do is make sure they can find the money and they can pay the rent, because we don't want them also losing their housing. So if we take out the 90 days, it forces them to then solve the problem sort of in real time. It doesn't give them any grace period. It does then revert them back to B1 and 2, of the ejectment. If the landlord has to move to ejectment because rent hasn't been paid, it then moves us back, I think, Cameron, to B1 and 2. Is that correct? I mean, I'm a little lost, quite frankly.
I'll try to answer a few things that I picked up on there. The statute currently is silent on bifurcating any lease agreement. So if a landlord were to move forward in trying to eject a party to the lease agreement, they would have to do it under one of the statutory provisions authorizing the termination of a lease agreement. If an individual tenant was committing acts of violence against another tenant within the same unit under the same lease agreement, currently, I imagine the landlord could move forward with ejecting the one individual. And my understanding is the landlord could probably move forward ejecting both. And my understanding from advocates is that's what this language is intended to prevent, because you want to protect the victim, or at least that's the argument, is to protect the individual who is the victim in that situation and not eject them because they are the victim of the actions of another individual.
So can I pause you there, Cameron? The decision about ejecting somebody who has a lease agreement, verbal or written, and the decision about who is a victim and what rights and responsibilities they should have are better left to the court than for us to try and put that in every landlord tenant agreement in the state. That's what I'm saying. This is why we need a landlord tenant court, but landlord tenant issues get figured out a lot during the relief from abuse order process. So I feel like we're trying to over legislate when most landlords, if they're small enough and the person is, right next door to them or something like that, knows what's been happening and would welcome this opportunity to bifurcate the lease and try to be helpful. If we're trying to over legislate for large federally regulated programs, then that's the problem. We shouldn't.
So what I hear, and we're at sort of 0 hour here. So I guess what I guess I'm hearing a suggestion from you, Keisha, is that that the courts are going to deal with this once there's a relief from abuse order and the ejectment process, that we really don't need this whole second instance of amendment. Is that what I hear you saying? That we enable the bifurcation.
We should say there should be the opportunity to bifurcate, and it should be reasonable. The bifurcation is the reasonable question.
But we have that in 5A and B.
Right. And then everything else is held then by who you have the lease agreement with and what rights they have in court from there.
Madam Chair.
Yes, David, I see that.
If I can. So I fully understand the intent of what we're trying to do. Unfortunately, it's bumping into the reality of landlord cash flow, whether it's 30 days, 60 days, 90 days. I do think the bifurcation effort is worthy and should remain in. I recommend that we hold this topic of the actual rent, how the rent is paid back and who's responsible for next year. And possibly, though, put it into the study. I know the study is about housing court. But maybe one of the questions that could be asked to that group is how to solve this particular aspect of this particular issue.
Yeah, I think they may, I'm not sure it's a procedural question for them. I think they're wanting to keep their thing to procedural.
No,
Well,
I
One
actually
thing that I
really
would
agree with
suggest
David.
that we think about is something like this, and we may not be able to do it in the 5 minutes that we have left.
Well,
That
that you
is
have
that
left, 'cause
you create a fund that is designed to provide this temporary funding for rent of people in this situation, to be a revolving fund to be repaid, and so that the tenant who is removed from the location has to pay back the back due rent into return to the fund if the fund has paid some of it. That way, you protect the tenant who is the protected tenant, and on the other hand, you provide a mechanism to provide the funding immediately that doesn't come out of the small landlord's pocket.
right. I think that's a great idea for next year.
I know.
And I think that's wonderful. I don't think we can probably do that
I've-
immediately without knowing who would contribute to the fund. But to go back to David's point, okay, David, what would you change here? You would take the idea of this challenge of the allow for bifurcation, allow for the courts to weigh in and help resolve the who pays the rent, and then take the question of the additional question to and add it to the court study.
Potentially. Certainly allowing bifurcation. The issue of reasonable opportunity, blah, blah, blah. I would strike B1, B2, B3, but hold the language for next year, hold the language for the study, whatever a good mechanism is to properly review it with enough time and enough committees to get it correct. That's my opinion.
So,
Madam Chair, so
yeah, Aisha, so I would,
I think if the courts were with us today, I'm guessing, but I spent a lot of time doing domestic violence
Yes.
cases in court. Then when there's a conversation about non-payment of rent, we're not talking about an immediate danger. The reasonable standard will look different to the court, but they also will be looking at the time frame in which somebody individually has to face eviction or pay their rent, etc. When you are talking about any type of violence, this is what I've mentioned before. The court will kick that into high gear because both the tenant and the landlord are then potentially in higher danger because of criminal behavior from the ejected party. So the courts are better equipped to determine when something stays in civil and superior court and what is considered reasonable, and when something moves to criminal court because there is an immediate threat of danger to all of the parties involved.
so with resolving this right now, what would we would keep the bifurcation language of section 1A and take it through 3, and then B you're both suggesting that we remove B in its entirety and instead come up with a recommendation for the court to consider resolutions of non-payment as a result of domestic violence. I mean, I need help from Cameron. We need some help here with suggestions on how to resolve this.
Yes. I will, if it's a policy decision for you all, I will echo what I was hearing from some members of the committee, which would be to strike B in its entirety. I think you were, that's what I was interpreting Senator Weeks to offer. And at that point, you would be left with A, which would authorize the bifurcation when it's requested in writing, and it would require the bifurcation if there's a court order that requires the perpetrator to leave. It would leave open the question of whether a landlord could move forward with terminating the rent based on non-payment of rent. And that would just be governed by current statute, which is if the protected tenant was not able to cover the rent for the periods after the bifurcation and ejectment of the perpetrator, then the landlord would just move forward as they do under current statute. If you were to remove B, that's my understanding of the request from the table. I will also, Madam Chair, I will comment that Katerina, who's here in the room with me, had her hand raised and wanted to chime in. I'm just mentioning that because you probably can't see her on the screen. Whether you call on her, that's up to you. I'm just letting you know.
Thank you, Katerina. Thank you for being there. It would be great to have you weigh in, but that is my understanding of what Keisha and David are proposing, and then adding a piece in the court discussion. Katerina, feel free.
Before she starts, this is the point at which, unfortunately, I have to leave for the day.
Yes,
So I
sorry.
regret that I have, but I do.
Thank you, Randy. We will share with you where we land later in the day and
Okay.
tomorrow morning.
Good. Thank you again.
Thank you. Katerina.
All right, I just wanted to say that this section was.
Identify yourself. Sorry, identify.
Oh, thank you. Sorry. Katerina Lasias from the Vermont Network Against Domestic and Sexual Violence. I think when we're talking about the first two sections, so A1 and A2, it is a request from the tenant. So a tenant who is in a situation where they know they cannot pay their rent will likely not ask to bifurcate because they don't want to risk homelessness. So I just want to make sure that's a shared awareness of the committee. That's part of why B existed, that there would be a possible grace period so that if they weren't able to cover their rent, there would still be an opportunity to stay housed. But I understand that the committee wants to further discuss that, but I wanted to.
We don't have, Katerina, thank you very much. I think we appreciate that. I think the challenge that we face in this committee at this moment is that the grace period can't allow landlords losing money. I think that's what I'm hearing. We appreciate that the trauma needs to be resolved and we need a plan forward for traumatized tenants to figure out how they're going to pay the rent if that's the problem. It may not be the problem for all victims of domestic violence. But if that is, I think we need more time in another bill for another day to figure out the grace period and it's so that it doesn't impact landlords. I think that we are going to have to settle at the moment with current law and to resolve that issue and strike B, go with A, and maybe add some language to the court study because we have to get this bill out today if we can.
So what I'm hearing you, Madam Chair, is strike B. I would.
Sorry, go for it.
That's great. I'm not sure what language you're thinking you would add to the court study, if it's a policy question of anything about whether or not, moving forward with some sort of time frame or reasonableness. I think the judiciary is going to come back and say these are policy matters for you all as the branch.
I agree. I was trying to say that earlier. I think this is going to conference committee, and if we have additional language, we can work on it and add it in conference committee.
So what I have written down for now, Madam Chair, if you'd like to take the straw poll from your committee members, is striking B in its entirety and leaving subsection A.
I think that's what I'm hearing from the committee.
I concur.
Is David, Thomas, is that okay with you? Oh, and Keisha. Okay, great.
Sounds reasonable.
I think that's what I'm sensing from the committee. I'm disappointed, but I appreciate this conversation. And so let's move to the third instance of amendment. I think we're all in agreement on 2.
Okay. The third instance of amendment is striking out section 3 in its entirety and inserting a new section 3. Fortunately, I have to strike the entire section and add it all back in, only to add this highlighted language here on the top of page 5. What I will do is I will first mention that you've already asked to change the word affidavit above. So on line 8, I would change that as well to the written statement instead of an affidavit. But the point of this section was to coincide with the above that requires that information to be provided. And this language beginning on line 8 would say that the complaint or the ejectment complaint that's filed with the court would have to include a copy of that written statement. And then on line 9 and 10, it would have to include a copy of any rent ledger if there is one available. So this is the language that was in the House version as it came over to you. And so if you're going to require that written statement above for a termination, require that written statement be included with termination notice for termination under B 1 or 2, then you want to require that information to also be filed with the complaint in court if there's an ejectment action filed.
Right. And I would support that as long as we remove the affidavit.
Yep. Affidavit to written statement. Okay.
And I confirm that the affidavit does require notarization. So let's definitely take the affidavit, including the written statement, I guess.
Right. It may require notarization, but there's a separate section that in statute that says for a document that requires notarization, if you include a specific phrasing within the affidavit itself, then you don't require notarization.
Right. I think the committee's feeling was to remove affidavit.
Right. Agreed. So we have written statement. Okay. So that's there. The rest of this is as the recommendation came out of Senate Judiciary. So for this section, it follows what was in the Senate Judiciary report, which is here on line 13 for section 4853A. We're making a technical change. Currently, there are 2 subsection A's in that statutory section, so you're deleting one of them. Then we get to the next section, 4854A. This is the section about the property that remains in the dwelling unit after the writ of possession is issued from the court. And at what point can the landlord dispose of that property that remains, and how long does the landlord have to maintain that property? We had a conversation about this a little while back, and I tried to pull up an Excel spreadsheet and demonstrate how the timeframes work, because I understand it can be somewhat difficult to understand without a visual representation. What this does is it says that immediately upon the landlord being legally restored to possession of the dwelling unit, the landlord could dispose of the tenant's property. And I've simply commented that that could be as short as 6 days. The Senate Judiciary Committee left this in as it is drafted, and it's here remaining in that state. And Madam Chair, Senator Chipman has to say that.
Yes. Sorry, I'm trying to find you on this draft and I'm completely not finding you.
Should be on page 6. Page 6, beginning line 8.
And then Thomas,
I'm gonna say what I said before. This section just doesn't feel right to me. It doesn't feel right to me that we are making it so that when this writ of possession finally occurs, the landlord can literally toss the stuff to the curb without giving people, I don't know, a day or at least a week to pick the stuff up. I just feel like landlords have some responsibility for the things inside of these locations to give them a window of time to go get them. So this is enough for me to be a no on this bill, but I could be persuaded if any tenant advocates could say that this is comfortable with, that they understand this process, and this doesn't give them pause. But it just seems to not have to hold on to this for 15 days is just kind of cruel. And the fact that they could just throw it to the curb as soon as they get possession, this is people's stuff in really rough times in their life. So I really need a tenant advocate to make me feel comfortable with this section for me to get to yes.
so thank you for, I believe we straw polled this before.
I thought we took it out. Yeah.
You should hold it for 4 to keep it in 3-2, I believe.
Oh. I'm a no, I'm with Thomas. I think this is a very important section. We talk a lot about property when someone gets evicted. We we had a chart that still didn't make sense to me. I'm a no on the bill with this section as well.
Well, I think it would require more time than we have to discuss it and to get everyone to yes. So I would also support probably taking it out at this point.
Senator Weeks has his hand up, Madam Chair.
Oh,
just-
sorry, David.
Yeah, thank you, Matt. Thanks, Tom. Yeah, we talked about this in committee and to me, it became clear that there was a notice period that the tenant knew that there was an eviction process that had been started, and that there was some number of days where they were aware of the point when they had to leave. And frankly, from my perspective, when the tenant leaves, property leaves with that notification intact. That's where I got to a yes on this, but
Right.
if it's too complicated right now, I support striking it and we can carry this conversation.
I think this conversation is going to be robust next year, and I would suggest striking it for the moment and having it revisited next year.
Striking section 4854A.
Correct. I believe that's those are that is what you're talking about.
Yep, okay. Just making a note for myself. So, all right, moving on to the next instance of amendment. Because that's the end, so that takes you all the way, because there's a sub A and a sub B in that section. So now we're on page 7.
We're on page 7 with the 4th instance, the 5th instance, and the 6th instance.
Yes, ma'am. And so these are related.
8. We have eight instances.
Yep,
Madam
so
Chair.
Yes, David.
Chair, just to set expectations, I'm really under a time crunch today. I cannot, absolutely can't go beyond 1 o'clock, and I'm under complete duress being here right now.
Okay.
Try to support the committee, but no.
Thank you.
no
We
later.
will end at 1.
Thank you, ma'am.
correct. So the 4th, 5th, and 6th instance of amendment are related to the trespass language. And in the 4th instance of amendments, so here's where I commented the last time we were here. I pulled up the Senate Judiciary Report and I, reflected on where it's allowing a landlord to issue a no trespass order if one of 4 conditions are met, the tenant consents to it, the individual guest has violated the terms of the lease agreement, the individual guest has violated state or federal law, or the individual guest has previously been ejected from the property. And so there was a request for subdivision B, which is to issue a no trespass when the guest, who's subject to the no trespass order, has violated the terms of the dwelling unit's lease agreement. There was a request to add in that it be a pattern of violation. And so what you have here is adding that in where the invitee or licensee subject to the order has engaged in a pattern of violating the terms of the lease
Right.
agreement.
Right.
And-
Thank you. This was something Keisha had wanted to add, and I'm fine with it. I thought the committee was fine with it. So I think we're a check on this one. Are people okay with it? Great. Then let's go to the 5th instance.
Okay. Well, before I go to the 5th, I would just comment the 6th, which I will just mention, and it sounds like you're all okay with it. Pattern of violating is defined as 2 or more acts over a period of time, however short. So those two go together.
Right.
You have the 5th instance of amendment, which is where, as I mentioned a second ago, the landlord can issue the no trespass order if the if the guest has previously been ejected from the premises, and it was limited to an ejectment under 4467B. So you would not be able to issue the no trespass if the individual had been ejected due to non-payment of rent or due to a no cause eviction. It would have to be an ejectment under the breach of the terms under B1 or 2. And the request from Senator Ron Hinsdale was to further limit that to only ejectments due to B2. And so that's what this 5th instance of amendment is doing. It's adding subdivision 2 after 4467B.
So just say that without the numbers, that would mean that the no trespass would only work for violent behavior?
Yes, you would only be able to issue the no trespass order if the person had previously been ejected under B2. So it would have to be due to criminal activity, illegal drug activity, or acts of violence. So if you had previously ejected the tenant under B1 because the tenant failed to comply with material terms of the rental agreement or with the obligations imposed, don't know why my screen just did that.
Yeah.
Then you would not be able to issue a no trespass if you eject someone under B1, only under B2.
Right. And I think we had some discussion of this. I am fine with this at this point.
I get it. Well, I think that's a good change.
Yeah. And Thomas, you okay? Okay, great. Last 6.
Yep. Moving to the 7th instance of amendments, which is top of page 8. This is
Wait a
deleting.
minute, what happened to 6? I thought we were on 6.
I
Oh,
mentioned
more of the pattern.
the 6th instance coincides with the 4th
Yeah,
instance.
got it.
So now we go to the 7th, which is deleting sections 7, 8, and 9. Section 7 was the positive rental payment credit reporting pilot program. Section 8 was a transitional section related to security deposits, which is no longer necessary. And
Right.
Section 9 was the CBOEO landlord and tenant training. Those have been removed because they weren't funded. And then you get to the 8th instance of amendment, and in the 8th instance of amendment, it is striking out the study and report from the judiciary related to this dedicated docket. And you've made a few proposed changes here. For starters, I've changed it from a housing docket to a residential rental docket.
Right?
Then you get to page 9, and there on sub 4 was a request to include some information from the language that was in subsection B related to the procedural impacts of when to begin the 21-day timeline, whether it should be filing of the complaint versus service of the answer.
Right. And this is all language you and the court worked on together. You and Terry worked on this, and I believe the judiciary has signed off on this language.
That is my understanding as well. When you look at subdivision 5 here, there was a request from Senator Ron Hinsdale to include whether to include other legal matters beyond residential rental agreements within the dedicated docket itself, or whether it should be just limited to residential rental agreements. There is still this subdivision 6 of kind of the catch-all, any other matters deemed relevant to the issue of implementing a statewide residential rental docket.
So why do we need 5 if we've given them 6?
I think the request from Senator Ron Hinsdale was to replace 6 with 5, and I've kept both.
Terry agreed to 6, so I'd kind of like to stick with what Terry and the court agreed to.
Okay, well, so I specifically said, I just think 6 is like do you have anything else to add? My kids are with me. And 5 is much more specific in my mind too. And I can't imagine them being upset about when they're considering being asked to specifically answer, does it make sense for us to talk about landlord tenant law or other commercial property law beyond residential rental agreements? I'd like a specific answer to that question, which is usually why we ask for studies, not to say anything else you think is important.
Oh, then I think it's 5 and 6, not 5 replacing 6.
Well, you thought 6 covered it, but then 6 would cover everything. So I'm just saying this is specific information I would like to know when they complete their study.
I appreciate that. But I would have 5 and 6 then. And because there may be some other things that crop up during the course of their work that they may want to raise. So I'm open to having, I think 5 and 6 makes sense.
I'm okay with both.
Yeah.
There was a lot of language in a subsection B that has been struck at the court's request. There was some from the judiciary about straying from away from procedural matters and straying into policy questions. So their recommendation was to strike that entire subsection B. So it's not reflective here. And then lastly, there is what was subsection C is now subsection B, and it requires the court administrator to consult with interested parties, including landlords, tenants, Vermont Legal Aid, and others deemed necessary. I believe the previous language said that the court needed to take into consideration the interests of other parties, and the judiciary was a little concerned with that. So this would require them to consult. And then the last is this last two sentences here, which is after the bill is passed, that the bill be amended to read an act relating to residential rental agreements, ejectments, and unlawful trespass. Currently, the language talks about residential rental credit reporting pilot program, which you are proposing to strike. So it no longer makes sense to have that in the title of the bill. So you're renaming the bill to be accurate.
Okay, I think I am fine with that entire section. And I think, how is the rest of the committee on that? I think that you guys we did good work. I think how are people with everything except on, I think there's agreement from what I can gather on everything except page 2, which is, number 4.
The disability protections.
No,
Oh.
the
Overdose.
judiciary, the Good Samaritan piece. So I think we're fine on the bill on everything except, from what I'm hearing, with all the strikes and the changes we've added, and the strikes and the additions we've made. I think my
I'm
sense.
sorry, I have to go chase my toddler, but I had wanted to discuss the disability protections. That was important to me for a yes vote on the bill. But I have to go on mute.
We took care of that. I believe it. I thought we took care of that earlier.
No, there was language, if you recall, we were discussing this the last time we met.
Yeah.
There was a request from Senator Ron Ensdale to include a prohibition on terminating a rental agreement due to breach of the material terms under B1 if the activity giving rise to the termination was due to an individual's disability.
So remember, we straw polled this and we agreed 4-1 to not include that language because people didn't feel that.
Okay, well, this kind of takes me back to, in the beginning, you said nobody raised concerns that you were aware of before we vote.
We were having this conversation, and I think.
But a lot of new language was worked on to address the concern.
I thought the new language was adding the reason for a termination. I did not work. I didn't know that anyone was working on additional language about that. Because I think the committee, after all that discussion, Randy's concern was, well, a mental health challenge may be a disability, but it may be incredibly disruptive to the, that can't be a reason. I mean, there was a pretty fulsome discussion about unseen disabilities and.
Mommy. Hi, Mommy. Hi, Mommy.
So that conversation kind of veered into the overdose type circumstances, and we did receive an email from Brenda. I don't know if you saw that, Senator Weeks, yet, but I agree, Chair, that we didn't conclude in that discussion that the language is needed, but I wonder if Brenda's email actually puts this in a different perspective, separating and distancing it from the overdose concerns. I don't know if you have thoughts, Senator Weeks.
To be honest, I haven't read her email. This has been quite a hectic weekend. I can certainly make sure I'm well versed before we reconvene, but my apologies. I have not read her email. I'll make a note of it though.
And I don't recall new language being worked on in this. We voted 4-0 to not, and 401 to not include it.
I think but I think I wasn't here at some point.
Yeah,
I'm trying to remember.
You're right. You left the discussion, but the discussion was
speak in natural resources. But I think some misinformation was kind of not addressed, which is that you can't engage in a pattern of behavior of any illegal activity and be covered for your disability. What we are talking about is an ejectment process, even if you have a rental agreement, and no trespass if you don't have a rental agreement, that centers a lot on, you know, this person who is on the lease agreement having a lot of agency. We have to worry anytime we change landlord tenant law and we're affecting people with disabilities, because they are often a very vulnerable population, for people to come squat in their property and really deteriorate their relationship with their landlord, or cause them to lose their own rights without much regard for that person. People with disabilities essentially are often taken advantage of for their housing, and they are the ones that face the most consequences for that.
So given the time frame that we're in, I would ask you to work on language to present to us tomorrow that we might consider. We'll meet 9 to 10. I know Randy and David have another meeting, but we'll meet 9 to 10. We'll hope they're able to join us during the course
Well,
of that.
with our last 8 minutes, can we look at the last thing we had drafted? Because there was never a problem with the language, I don't think.
I think there was a problem with the concept of people, using a disability as yeah. So I didn't know that we had language in addition to what we were looking at, because the committee pretty much decided no on the language that we were looking at. Was my understanding. Cam, do you have language that I just don't know about any additional language? Cameron?
I don't have any new language other than what you all were discussing last week.
And we agreed to not include this language that we had looked at. A landlord, right. I thought that was what we had agreed. If there's additional language for us to review, we could look at it, absolutely look at it tomorrow.
So
The washing machine.
I think, I've struggled with whether I'm a yes or no on this bill, as you know, from the beginning.
So if you have additional language, Keisha,
Yeah.
I'm happy to look at it tomorrow, but we don't.
So, but can you speak to this language while we have 7 minutes, and what the existing concern is? Because I had to leave to go speak to natural resources, and I'm not clear if the conversation was about the letter of the law here and what's written, or about some concern that this would allow for like unfettered drug activity or something because someone has substance use disorder.
No, help me, committee, and Cameron, I believe that the conversation was about using, yeah.
So as I reread this, I am more comfortable because of the clarifications that came up in that discussion. I really want to hear from you, Senator Weeks. And if you do take a look at Brenda's email, I don't know if it's not too long, but this section B makes clear to me that if the disability can't be used to justify, or even if it's a mental health or anything related to drugs. But again, I think we clarified that if you're abusing drugs, that it's not protected. It's only that if you are in recovery, then it is a somewhat protected class, but really more employment law than landlord. But section B tells me that if the behaviors are violent, if they create health and safety threats, or if it's criminal in any nature, then that disability is not a protection at all. So I am relatively comfortable that this is focused on genuine disabilities and not using disability to justify or weaken the ability of landlords to extract or to evict problematic tenants. I don't know if you have any thoughts, Dave.
So, just real quick, just to clarify though, if you limit the 5A to subsection 1, you don't need the 5B. And what it would do is it would authorize Or it would say that if someone was breaching the material terms of the rental agreement, or they were not complying with the obligations imposed under the chapter, then the landlord would not be able to terminate the rental agreement if the activity in question that gave rise to the termination, so the activity that was violating material terms or was violating the obligations imposed, if that activity was a result of someone's disability, then you would not be able to terminate the rental agreement. But I just wanted to clarify, I ended up removing the B, because if you limit it to subsection 1 in the 5A, you don't need the B anymore.
Can I just say maybe the B is like belts and suspenders to some people, and we leave it because it makes it really clear you can't engage in criminal or violent activity. Yeah, I'll leave it at that because we just have a couple minutes. But I feel this whole section is very important.
So if somebody's disability is allowing them not to work and they don't have the money, I mean, does this allow an ejectment to continue if somebody's not paying the rent?
It would not cover a situation for non-payment of rent, no, but I just, in response to the other comment that was made, if you're going to keep something like B, then, my question would be, are you adding in illegal drug activity? Because B specifically talks about, kind of the items listed in subsection B2. So if you're going to add kind of belts and suspenders language and you intentionally leave out one of the provisions in B2, you're signaling to the court that that's not your intention. So if you're going to keep a subsection B as it's kind of written on the page, I think you would potentially need to be careful about including it and how you word it.
Got it.
Is
Got
it, Cameron, can I ask, is it conflicting or is it a compromise? Because I am basically the crux of a lot of our arguments have been is like a pattern of illegal activity, a problem for a landlord or other neighbors that they should be allowed to address. And I think I think a court or a reasonable person standard would look differently at a relapse in the home than they would, people going in and out exchanging guns and drugs.
Okay, but that's not what this is about. This is about a disability that there would be, that a landlord could not terminate if a person's disability meant they weren't able to meet the rental agreement requirements. So I don't really fully appreciate what that could.
Well, Madam
that
Chair, I think you just heard that you're working to understand this piece altogether, that we are specifically focused on B1 and 2, which is the difference between any breach of the rental agreement and criminal or violent activity.
Right. And obviously that would be excluded for a person with, so I would suggest, given we have 2 minutes left, that we take this issue up again tomorrow morning between 9 and 10. I know David and Randy will join us, but we can maybe work on getting this language to a place where at least all of us can, we can have some agreement on this. And then we need to revisit number 4, I believe. And that is the last, those are the 2 outstanding pieces, the disability language and number 4, the Good Samaritan piece. Because I think other than that, we've done I think we're in agreement on pretty much everything else. I think the disability language I may be getting more comfortable with. And I think we just all have to understand its full implication.
Senator Weeks' time is up, so I guess we'll pick this up at 9 a.m. tomorrow, and hopefully we'll all be in where we are.
Yeah, thank you. I think that does us for today. Thank you, David. Thank you, Keisha. Thank you, Tom.
Thank you all.
Randy, Cameron.
Good conversation.
Katrina.
Thank you.
We will see you tomorrow. And what?
One question.
Yeah.
H775, when do you expect it should be on notice for?
I don't know.
Wednesday?
It has to come out of natural resources. and it still hasn't done that. And then it goes to finance, I believe. Is that right, Cameron?
I believe it will go to finance, but that is a decision of your secretary.
Right.
Okay.
So thank you, everyone. Cameron and Kiara, if you could stay on just for planning purposes. Everybody else, we'll see you tomorrow. And we'll see you, David, as soon as you can. But Keisha and Thomas, we'll see you at 9. Great. Thank you.